when you wrote 25.3 in relation specifically to Mrs. Mukwele, on what basis did you conclude that she was going to collude in the looting of state funds with whomsoever?
I recall that when it came to where she was positioned in TSS, TSS is a covert environment with a very big budget. And the allegation was that if monies were needed, as an example for the purchase of properties, monies would be able to come out of there. And that if she was asked, because of disappointment, she would have felt the need to act. That was the projection, and that was the understanding of where.
Sorry, as to do what exactly?
Sorry. If monies are required or needed, the technical support services to which she would have been appointed has a very big budget. It is a covert environment. And I think the manner, and I'm giving you the explanation as I understand it, the manner in which funds are dealt with are not as open source as everything else. And so should the need arise for funds to be procured, that would be the environment from which funds could be accessed, for example, for the purchase of properties. That is how I recall.
Unlawfully?
That is correct.
So she would violate her duty of good faith to her employer. She would breach her contract of employment.
I think the contention, Commissioner Khumalo, if I recall correctly, was because the monies are in that environment, she could be approached to make those monies available. I don't know what would be presented to her for her to make those monies available, but that is where the funds are for her to make available.
But if she's doing that as part of her job, how does that rise to gratification and unlawful conduct? Because what you are saying, that would apply to any person who occupies that role. Correct. If they are required to provide money, provided that they are complying with the prescripts and they are doing that correctly, that's not a criminal offense.
No, it
They are
isn't.
simply doing their job.
Yes. If she was approached for access of the TSS funds, knowing that whatever that motivation was, she should not approve that funding.
Yes, but how do you leap to the conclusion that she would loot state funds? Because that's what your 25.3 says. If she's approving a request and she's doing it in accordance with the prescripts, there's nothing wrong with that.
Not if she's doing it in accordance with the prescripts.
So what is the basis of your assumption that she would have done it in an unlawful manner?
That she would have been approached to make monies available under circumstances where she would not have made them available.
But how do you know that?
That was because of that environment and because of the fact that from previous matters, not in IDEC, that is how funds were looted, out of accounts where the funds are within a covert environment. So motivations would be put in for access of that money.
You are being, if I may come in, no. You are being grossly unfair to Mrs. Mukwele. Now you are attributing conduct of persons she has no knowledge of to her in the future know-how. And you are saying you accept that she may be required to access those funds in the course of execution of her job. But the impression you create here at this 25.3 is that she would do so to loot. So that apology that I think you sought to extend to her, you might as well take it back. You are seriously impugning her credibility, and we're trying to find the basis on which you say she was going to loot.
I hear you. That is not the intention. I'm trying to give an example of how I find that space. I think it is also wholly unfair. There's no intention to impede on her dignity. I am merely expressing or amplifying on the question. If that is how it comes out, Council, really, it is unfortunate that you think that I would, in giving an explanation, that I am intentionally impeding on her reputation and her credibility. I do apologize if that is how it comes out, but, and to say that my apology, in fairness, Commissioners, that I made earlier, I will not willy-nilly make an apology. The Commissioners did not drag an apology out of me. I made that apology freely, and I think it should be taken from where it came. It did come freely.
You see, if there were substance in what you are saying, it would apply across the board. That is to anybody appointed to that position.
Correct.
That must be correct.
Yes.
Yeah, because you have no basis to think that she is different, and that therefore this would apply only to her. So anybody,
In that position.
if what you say is logical, anybody would also be susceptible to this impropriety.
I accept that, Chair.
Thank you.
Advocate Johnson, in June 2025, this is exactly the charge that was presented, even in the draft charge sheet to justify Ms. Mukwele's arrest. It's exactly this. So she has gone through all of this over a period of a year. It's not new that for the first time today you are making this allegation. The memos, the draft charge sheet, and all the documents, this was exactly the issue. And I say this for my part, I have no sympathy for people who loot state funds. And if there are people, whether they are generals or not, who are involved in the looting of the secret account or whatever it is, I have zero sympathy for them. But this case, as Commissioner Baloyi said yesterday, is a serious abuse of power by IDEC to target a civilian. And that's what I have a problem with. My sympathy for her is a bit different to the generals, because if they did what they did, the law must take its course. But we must draw the line where organs that are supposed to protect the public and, work for the benefit of the public are used in this manner to unfairly target civilians. That is just not right.
Our concern is, how do you make this charge, for example, how does that allegation even arise that she is potentially guilty of a PRECA offense of gratification? But not just her. And she has been the focus of Commissioner Khumalo because she's a civilian. But any criticism that comes out of Section 25.3, in my view, applies to everyone that you have charged with an offense of gratification as defined in PRECA. And it comes from, but there are no facts alleged by Mr. Adams, the aunt, not in his Section 27, not in the affidavit, that paragraph 2 that speaks only about Ms. Mukwele's appointment. Nowhere else does he make allegations that form a reasonable basis for you to prefer a charge of gratification as defined in PRECA. That is really the issue, right? And so the inquiry to you is, why did you authorize that? Why did your investigators get to that point? Why did the prosecutor, firstly your internal prosecutor, get to that point? Why did your DPP, who said, I concur, with the charges, they are good. What were they working off? So we're still at first base, before representations and before a review. Where does this all come from, right? And on the face of it, so far, between you and Colonel Pareachi, you haven't given a satisfactory explanation, I must say. And I accept that you're still going to give us documents, the A1 statements, and maybe we'll see from there what were the facts that led to this allegation in 25.3, but also that led to the charge itself. Absent that, if you do not have documents that show the facts on which this charge or this 25.3 is founded, if you don't have any such documents, then this was an arbitrary decision not based on any facts, and because of it being an arbitrary decision, it is a use of investigative powers for ulterior purposes. If it is not explained satisfactorily for ulterior purposes, then we have to ask the question, what was the purpose? I hope you understand.
I do understand.
What I'm saying, yeah. So we still have to answer that question.
Correct.
And hopefully your statements will the A1 statements will put us at peace that, well, there was a basis for that. But as matters stand, I must say, from where I'm sitting, that with everything that is before us, and until we get something else, then the exercise of the power to investigate and to charge an offense of gratification under PRECA was exercised without proper consideration, without facts placed properly, and I underline properly, placed before you for this and the prosecutor and all the people that I've listed to formulate that charge. On the face of it, the power that you have, all of you that I've listed, you exercise it for an ulterior purpose, and hopefully by the end of the evidence of the IDEC witnesses, we will find out what was the purpose. That for me is the real issue here.